Hello and welcome back, my law lovers, to another episode of Legal Insight Unwrapped. Today, guys, I do want to talk to you guys. I want to share the supplemental brief that Fani Willis filed. I think she filed this actually a day or two ago, but it's concerning the standard of proof for disqualification. And she makes some pretty compelling arguments here. So I want to jump back in and we'll go right into that and review it and see exactly what Miss Fani Willis, how she's trying to persuade the judge to rule in her favor. Let's take a look at it. Okay, let's take a look at the supplemental brief that Fani filed. Again, this is in relation to the standard of proof that she says needs to be established in order for disqualification of a DA. So let's see what this says. So this was filed on the 5th. So this was a couple of days ago. State of Georgia versus Donald Trump et al. And you guys see all of the names there that are listed. All right, so let's move on down. So first section, the state's supplemental brief following the hearing on March 1st. This is concerning the standard of proof and the legal standard for disqualification on an elected DA. Okay, and this is really important because this is the standard of proof based on the legal standard. So let's see exactly what she is stating here. It says, at the hearing on March 1st, 2024, concerning the defendant's motions to disqualify District Attorney Fani T. Willis, the court posed several questions to the parties concerning the standard of proof required for disqualification and the legal standard to be applied by the court. Okay, let's go over that again. She's stating that the judge asked several questions to both parties, the plaintiff and the defendant, well, the state and the defendants. He was asking for what is the standard of proof that's required for disqualifications? What does he go by? And what is that legal standard, the legal standard also that needs to be applied by the court? So he's looking for some direction. It says the binding case law in Georgia is clear, okay? A trial court is not authorized to disqualify an elected district attorney absent a showing by a high standard of proof that such an elected district attorney either has an actual conflict of interest or has engaged in forensic misconduct. Okay, so this is important. Let's go back and look at that again. So it's saying that the binding case law, she's found some case law in Georgia, is that the trial court, which is where they are now, they're not, she's basically saying, listen, you're not authorized to disqualify me as the DA unless you can show a high standard of proof that such an elected DA, which is what she is, has an actual, this is where it gets interesting, an actual conflict of interest or has engaged in forensic misconduct. This actual conflict of interest is definitely not something that the judge stated. This is not the direction that the judge was going in early on when the hearing first started. He actually stated that it was the appearance of a conflict or an actual conflict of interest. Again, guys, the appearance of a conflict of interest. She's basically stating that that's not so, that the case law is stating that in order for an elected DA to be disqualified, they must show an actual conflict of interest or that the DA has engaged in forensic misconduct. And let's keep going though. So this brief will address that standard of proof recently recognized by the Georgia Court of Appeals and few circumstances recognized under Georgia law that constitute actual conflicts of interest for prosecutors. Okay, so she's doing some case law. She's looking at the previous cases. She's trying to determine where do we have something that matches the conflict that we have now. Something that shows that a prosecutor has a actual conflict of interest. And then, I don't know if you guys recall, but in the hearing, the Senate hearing with Ashley Merchant, this question was also asked, what's the case law say for prosecutors and the actual conflict of interest? And Ashley Merchant's response was that there really hadn't been any in the state of Georgia. They really didn't have anything to go by. If so, they would have presented that earlier on. But let's keep going and see exactly how Fani frames up her argument to persuade the judge. Okay, so she says, as a threshold matter, okay, so this is the threshold, guys. The elected district attorney is not merely any prosecuting attorney. She's saying, I'm above this. You know, I'm not like these regular Joe Schmoes. I'm not just a regular prosecutor. I am an elected district attorney. Did you guys get that? So it does set somewhat of a difference. It separates her from the other prosecutors that are working under the DA's office. So she says, as a threshold matter, this is a threshold for an elected DA, okay? Not just a mere prosecuting attorney. She is a constitutional officer, and there is only one such officer in each judicial circuit, okay? Did you guys get that? She is a constitutional officer. There's only one such officer in each judicial circuit. And this is based on McLaughlin versus Payne, 295 Georgia, and then they give they're citing it, whatever, they give the sections. They're citing Georgia Constitution of 1983, Article 6, Section 8, Part 1, Paragraph 1. Okay. Under Georgia's Constitution, a district attorney is constitutionally mandated. And notice she put that in, she italicized that. Again, under the Georgia Constitution, a DA is constitutionally mandated to represent the state in all criminal cases in the Superior Court of such district attorney circuit. And then she cites where she got that from, okay? Let's move on down. Here, the district attorney seeks only to do exactly that. So basically, she's saying, I'm only seeking to do exactly what I've been elected to do, and that is to represent the state in all criminal cases in the Superior Court within the DA circuit, okay? So again, she said that here the DA seeks only to do exactly that, perform her solemn duties as mandated by the Georgia Constitution to subserve public justice in a case of great public importance. And then she lists the case here. See State versus Sutherland, whatever, 190 Georgia Appellate 608, 606. Okay, let's move on down. The defendants asked the court to impose a novel hair trigger standard for the disqualification of an elected district attorney. Okay, did you guys catch that? She's saying, look at this. The defendants, so this is Trump, this is Michael Roman, this is all those defendants on the other side, right? She's saying you're asking the court to impose this new standard to disqualify me, hair triggered standard. You're pulling it out of thin air. You know, it's based on basically nothing that is substantiated. And she's saying you're asking the court to disqualify an elected district attorney, not a regular prosecutor, but an elected district attorney, which does seem to hold some weight when you think about it, because this is the district attorney that the people have chosen, if you think about it in that regard. But she goes on to say, but no such standard exists under our law. So there is nothing for and this is what Ashley Merchant mentioned in the Georgia Senate hearing the other day. They don't have anything to go by in terms of a conflict of interest from a elected district attorney, or for that matter, even a prosecutor. They've never had that sort of circumstance where there's been some sort of conflict of interest, especially one like this, right? Okay, so let's move on. The true legal standard, again, the true legal standard set forth by our appellate courts and confirmed by statutory language is much higher and requires proof of an actual, palpable conflict of interest with a substantial basis in fact. Again, now this is just so contrary to what the judge initially said earlier that I'm having a hard time seeing this as fact, because he made a point of saying an appearance of a conflict is grounds for disqualification, not just actual conflict, but appearance of a conflict. And here she is stating that the true legal standard, the real legal standard, is set forth by the appellate division, by the appellate courts. And she's saying that it's confirmed by statutory language, so that the standard requires some proof of an actual palpable conflict of interest. There needs to be a substantial basis, in fact, and she does state Lamb versus the state, and this is a 1996 case. Now, she says that standard is high for a reason. The public interest in seeking justice is in no way served by a low standard, which makes sense, that would allow trial courts broad authority to invalidate the public's choice in their elected district attorney selected by the people. Let's move on down. Let me look at the footnote in a second. To carry out the essential constitutional duties. Okay, so she's basically saying this is a you have a high standard because what I just mentioned a second ago. She's not just a regular prosecutor. She is an elected district attorney. She's saying, I'm selected by the people. There needs to be something higher when you just decide to kick me off of a case to say that the DA, the elected district attorney, is not able to fulfill the requirements that the state, that the people have, empowered her to fulfill. That it should be a high standard and not this low standard that the defense is trying to persuade the judge to follow. So that is what she is stating here. Let's move on down. He says our state Supreme Court reinforced this high standard just weeks ago. See Lee versus the state, and this is actually 2024, so some recent case law. Okay, as she moves on down, she says all criminal defendants have certain rights that must be protected by our system of justice, but among them is neither the right to be tried by a prosecutor of his choosing. So basically, and this is Neal versus State, 252 Georgia Appellate Division. She listed sections or whatever. Nor the right to delay his prosecution for no good reason. In Terrell versus State, she's basically saying here, you don't have the right to determine exactly what prosecutor you may of your choosing that you may have. You don't have that right to do that. And you don't have a right to delay the prosecution if there's not a good reason to do so. And she's insinuating, or she's not really insinuating, she's actually kind of stating it. Basically, that these defendants, is what she's arguing here, that they are trying to choose a prosecutor, or they want another prosecutor just because they want one, but they don't get that right as a defendant. You get a right to be heard in court, but not a right to choose the prosecutor of your choosing. So that's what she's stating here, okay? She said inappropriate or improper disqualification of a district attorney elected by the people of this county and constitutionally mandated to represent the state in all criminal cases in the superior court of this circuit has severe consequences. You guys seeing this? Again, inappropriate or improper disqualification of a DA, a DA that's elected by the people by the people of the county, constitutionally mandated to represent the state in all criminal cases in the superior court of this circuit, has severe consequences, both for the people's faith in their constitutional right to be represented by a district attorney elected by them. So honestly, I don't know how she even put that in this briefing. I don't know, in this supplemental brief, I don't know how she put that in there, given all of the information that has come out regarding the nature of her relationship with Nathan Wade and the appearance of, benefiting from the relationship in some regard. I mean, just the amount that he was paid, and then being able to go on all these trips. I mean, I think the public's confidence, for the way I'm reading this, the public's confidence in the system in Fulton County is compromised based on the revelation of her actions. So the fact that she could put this in here is really making me scratch my head like, wow, she's ballsy. She's ballsy. Okay, let's keep going here. It says, for the reasons set forth below. Oh, before I do that, let me just say this also. By saying that it has severe consequences, this is a very Democratic-led, county. So if it's perceived that he has inappropriately or improperly disqualified her, to me, this could even be taken as a thinly veiled threat, like it's going to have severe consequences. You're an elected official, I am an elected official. I'm an elected representative. So you take it as, I don't know. I might be reading too much into it, but for me, that's kind of what I thought. This is just what I'm getting, because I haven't even looked at this to read it the whole way through. We're just kind of going through this, but just to state that and then to actually put in here the public's confidence in the system of justice. Oh my goodness. Okay, let's just keep going. Okay, number one, the defendants bear the burden of proving their claims by a high standard of proof, which necessarily must be more than preponderance of the evidence. Okay. It must be more than preponderance of the evidence. It is the burden of the party seeking to disqualify counsel to prove that the extraordinary remedy of disqualification is warranted. And that's Lewis versus the state. That's in 2011. Okay. Actually, I will say this, they did some pretty good homework to kind of frame up her argument because there really wasn't much case law to support her argument. And she's finding little bits and pieces to support exactly what her argument, and just trying to persuade the judge in her favor. So I will say, whoever wrote this brief, they did a good job. Okay, let me keep going. In McGlynn versus the state, 342, this was again recent, 2017, the Georgia Court of Appeals recognized that a court considering a defendant's motion to disqualify an elected district attorney and her office based on alleged misconduct must hold those who allege such misconduct to a high standard of proof. Okay. The emphasis is added on high standard of proof. So we really need to figure out what this high standard of proof is going to be. At the hearing in this case, the defendants urged the court to adopt a preponderance of the evidence standard, but under McGlynn, that cannot be the correct standard of proof. While not squarely addressed in the context of disqualification, Georgia's appellate courts have often characterized a clear and convincing show of actual malice. Wow. She's saying that, wow. Okay, let me just go back and so we just look at this again. While not squarely addressed in the context of disqualification, which means they don't just head on address this disqualification, but Georgia's appellate courts, they have characterized, and she's saying often characterized, a clear and convincing show of actual malice as a high standard. And what is this? It should be as a high standard of proof. Okay, as a high standard of proof. And that is Terrell versus Georgia. And that is in 1994. It's again still recent. And you know what? If you think about it from that perspective, in terms of if there was any malice that was proven in the hearing, and I'd say probably not. I don't think that the defendants, the attorneys, showed that there was clear and convincing showing of actual malice. Now, that can be argued, obviously, but it doesn't look like it was malice, like it was malicious. It didn't seem to be that way. Okay, let's keep going. I'm going to skip this case law part because she does list some case law, and it's again fairly recent, and they did a good job of sort of piecing this together. But it says, moreover, the 11th Circuit Court of Appeals has regularly and explicitly recognized that preponderance of the evidence is not a high standard of proof. Okay, let's keep going. So the state maintains that the defendants have not established an actual conflict of interest, even by a preponderance of the evidence. But even so, based on these cases, specifically the holding in McGlynn, that trial courts must hold defendants seeking disqualification of a prosecutor to a high standard of proof. The court should hold the defendants to something higher than a preponderance of the evidence standard. Now, we can all argue whether or not this preponderance of evidence was proven or not. I'd argue that it was proven in terms of an actual conflict of interest. We shall see. Let's keep going and see what else they've put in here. Okay, number 2. The defendants asked the court to adopt a legal standard. Okay, this is different. They want to adopt a legal standard that is not recognized under Georgia law. This is what Fani is saying the defendants are trying to do. And they rely on cases that are either cited in a misleading way, are inapplicable, or actually support the state's position. She's saying you can't even get the cases that you're citing to persuade the argument on your behalf. You can't even get it right because they don't even support your argument. They're supporting my argument as the state. That's what she's basically saying. All right, let's keep going. The defendants rely on numerous cases in support of their motion that are either cited in a misleading way, are inapplicable, or support the state's position. The defendants can point to no appellate case because there is no case where an elected district attorney in Georgia was properly disqualified solely based on an appearance of a conflict of interest or other appearance of impropriety. Yeah, because we probably, haven't had a DA to compromise themselves in a way that it appears that you have. So no, there probably is no other case law there to support that. Anyway, let's keep going. It says, indeed, if such a case existed, it would undoubtedly have been brought to the court's attention by the defendants months ago. Instead, the defendants cobbled together flowery, righteous quotations from inapplicable cases that may sound enticing at first, but that entirely misstate the law in Georgia. In doing so, the defendants asked the court to adopt a novel legal standard for the disqualification of an elected constitutional officer. She said, I'm the head chief here, okay? You guys are coming up with these little hokey pokey legal standard theories. Okay, let me keep going. Standard for the disqualification of an elected constitutional officer that has never been recognized in Georgia and that is contrary to the decades of case law. Okay, you guys get that? Basically, there's no case law from the appellate division in Georgia that shows anything, that shows anything to support the defense's argument that she should be disqualified. Basically, is what she's saying. There's nothing. But again, how often do we see elected DAs have this sort of accusation held against them, that they've paid their boyfriend to work with them and the boyfriend has been paid this astronomical amount and they're taking down, a former leader of the free world. So, the whole thing is somewhat new and unprecedented. And we just don't see these types of things often. Any of it, all of it is fits in that within that realm. Okay, let's keep going. It says the cases relied on by the defendants can be divided into 5 categories. Number 1, cases that do not concern disqualification at all, but the defendants use as a source of flowery and righteous, though inapplicable language. Cases where criminal defense attorneys were disqualified on the basis of divided loyalty in violation of the Georgia rules of professional conduct. Okay, usually divided loyalty is in reference to when an attorney is representing multiple defendants and then you can't really be loyal to one defendant. So that is a case of divided loyalty. You need to choose one defendant. So that is probably, I got my law degree from California, not Georgia. But yeah, that is a violation. I'm sure it's a violation in Georgia rules of professional conduct as it is in California. All right, so let's keep going. Number 3, cases where a prosecutor had an actual personal interest or stake in the outcome of a prosecution. Okay. I do not think she has an interest or stake in the outcome of this case. I think she just wants to win for the sake of being able to say, I tried Trump and I won. So if you want to make that argument that that's her personal interest or her personal stake in the case, is just being able to say, it's ego driven and being able to say I did it, then maybe that. But other than that, she doesn't have any other stake in this interest in this prosecution. Okay, number 4, a single case where a defendant was denied a fundamentally fair trial where the DA had previously represented the victim in the case. Okay, that is not the situation here either. And number 5, cases where no actual conflict of interest was shown and disqualification was not proper. All right, guys. So these were the 5 categories relied on by the defendants. All right. Since the first category of cases is the largest, the court should categorically disregard them in the context of this motion, as they say nothing at all about disqualification of an elected district attorney. If you guys need to go back to see what number 1 was, it was cases that do not concern disqualification at all, but that the defendants use a source of flowery and righteous, though inapplicable language. All right, this is going down. A, cases involving criminal defense attorneys disqualified on the basis of the divided loyalty, as I mentioned earlier, are not applicable here, which they aren't. It says the second category of cases concerns criminal defense attorneys who were disqualified on the basis of divided loyalty in violation of the Georgia rules of professional conduct. specifically relating to representation of individual clients. These cases simply do not apply to the disqualification of a constitutional officer whose loyalty lies with seeking justice, not with any individual private client. And so, yeah, this is, yeah, totally makes sense within that regard. Beginning with Registe versus the state, the Georgia Supreme Court upheld the disqualification of a criminal defense attorney who had previously been directly involved in the defendant's prosecution, including filing an application for search warrants against the defendant. The court held that the circumstances implicated at least 4 ethics rules. And that was Rule 1.7, which specifically prohibited the attorney's representation of the plaintiff because the representation created a significant risk that the lawyer's duty to a former client will materially and adversely affect the representation of his present client. And because the representation includes the assertion of a claim by one client against another client in the same proceeding, the conflict cannot be waived. So do you guys understand that? Basically, it's saying that, okay, so this lawyer has this new client, right? And he also has a previous client that he represented, but the current client has made an assertion of a claim against the former client. And so the attorney really can't, he has a duty of loyalty. And he really can't be loyal to either if he's now representing a current client is suing the previous client. It just creates a conflict of interest here. And so it looks like the courts disqualified this attorney based on that. It says a lawyer who has formerly represented a client in a matter cannot thereafter represent another person in the same or substantially related matter if that person's interests materially are adverse to the interests of the former client. You see what I'm saying here? So former client interests are now, in jeopardy or compromised because of your new client, and you can't take that new client on. So, yep, that's what that is. Now it says the rules simply do not apply to the circumstances alleged in the defendant's motion. And they are correct on that. They don't. Okay, so let's move on down. It says the remaining cases in the second category follow the same logic as Registe. In Edwards versus the state in 2016, this is the Georgia Appellate Division, says a criminal defense attorney was properly disqualified. Again, here she's noted that he was properly disqualified, where he had previously represented the mother of the victim in the case, and neither Edwards nor the victim's mother gave informed consent. This is important, guys. Edwards nor the victim's mother gave informed consent to the conflict created by the defense attorney's divided loyalties. So you see what I'm saying? In both Brown versus the state, Love versus the state, defense attorneys were disqualified, were members of their firms. This is members of the firm, had previously been employed as prosecutors and were substantially involved in earlier stages of the defendant's prosecutions because they would know too much. You know what I mean? So they were disqualified. Okay, so finally, and it wouldn't be fair. There's a conflict of interest there. So finally, in Reeves versus the state, 98, a defendant's conviction was reversed where, one, his criminal defense attorney had accepted a job offer within this. Let me just go back. Okay. Reeves versus the state, 1998, a defendant's conviction was reversed where his criminal defense attorney had accepted a job offer with the same DA's office that was prosecuting the defendant. The record did not establish that the defense attorney had disclosed that fact to the defendant. The defendant asserted on appeal that disclosure of his attorney's future employment would have affected his decision-making. And 4, the defense attorney waived a jury trial, called no defense witnesses. He had a bench trial. So yeah, he waived the jury trial, called no defense witnesses, and he failed to have the bench trial transcribed. So the bench trial wasn't even transcribed. So while Reeves refers to an appearance of impropriety, it is factually distinct from the present motion. Was decided under the former ethics rules that do not apply here and is non-binding physical precedent. So let's move down to B. Cases involving prosecutors with a personal interest in the outcome of a proceeding demonstrate that no disqualifying conflict of interest exists here. Okay, again, this was what I was saying earlier. It really doesn't appear that Fannie has a personal interest in this outcome. I know that has been argued that she does. It has been argued that the longer this case goes, that the more money Nathan Wade made. This was argued in the hearing. But let's see exactly what she says here. She's stating that she does not have a personal interest in the outcome of this proceeding. So it says the third category of cases relied on by the defendants consist of cases where a prosecutor had acquired a personal interest in the outcome of the proceeding. In both Greater Georgia Amusements versus the state and Amusement Sales versus the state, special prosecutors were disqualified from civil asset forfeiture proceedings where they were paid on a contingency fee basis. Okay, they were disqualified from the civil asset forfeiture proceedings where they were paid on a contingent basis. While Greater Georgia Amusements refers to the appearance of a conflict of interest necessarily created by such a contingency fee arrangement, the case was ultimately decided on public policy grounds, not conflict of interest grounds. So that reference is dicta, application of a legal standard that the court merely assumed and explicitly did not adopt. And she itelicizes this did not adopt, but they did assume it. Okay, let's see. Let's move on down. And she does know dicta is not, it's not binding, which means the court don't have to follow that rule. They don't have to do this. It's not precedent. They don't have to follow. So it's not binding on anyone for any purpose. Okay. Let's move on. Moreover, Greater Georgia Amusements is non-binding physical precedent. And fewer than 6 weeks after it was decided, the binding Better Reason opinion in Amusement Sales, Inc. held that such contingency fee arrangements created an actual conflict of interest in light of the special prosecutors having a personal financial stake in the outcome. Okay, so they were saying that the contingency fee arrangements with those attorneys created an actual conflict of, and that's important. Remember the actual conflict of interest in light of the special prosecutors having a personal financial stake in the outcome. Okay, I have to read that case to see how that applied because just looking at it, I'm like, oh, how did they have a personal financial stake in the outcome? Just because they were there was a contingency fee arrangement. So they didn't really expand on that enough for me to really understand how this was decided. It does not make any sense. I mean, I could look at the footnotes, but let's keep going. It says in the remaining cases in the category, disqualification was appropriate based on actual conflict of interest. So in Young versus the U.S., this was back in 87, special prosecutors in a criminal contempt action were disqualified because they also represented the plaintiff in the underlying civil injunction action that gave rise to the criminal contempt action. And their prosecution of the criminal case gave them a bargaining chip in the civil negotiations. Okay, that makes sense. By the same logic, in Nichols versus the state, Georgia, 1916, the Solicitor General was disqualified from prosecuting Nichols for perjury in an underlying civil personal injury action where the Solicitor General, in his private capacity, also represented the personal injury plaintiff against Nichols and allegedly used the criminal prosecution to force a settlement in the personal injury case. Okay, this case is clear conflict of interest, the one that she's citing here. Okay, so let's move down. And she said that this was based on an actual conflict of interest, and it does sound that way. And she's saying basically this doesn't apply to her. So it says, as this court correctly pointed out at the hearing in this matter, and as these cases demonstrate, to create a disqualifying conflict of interest, a prosecutor's alleged personal benefit must be material. Okay, there must be some factual relationship between the alleged benefit and the prosecutor's involvement in the case in order to show a personal stake or interest in the outcome. Okay, let me read that again. So as this court correctly pointed out at the hearing in this matter, and as these cases demonstrate, to create a disqualifying conflict of interest, okay, a prosecutor's alleged personal benefit must be material. There must be some factual relationship between the alleged benefit the benefit and the prosecutor's involvement in the case in order to show a personal stake or interest in the outcome of the proceedings. I don't really think that's difficult to show. I really don't. I really don't. It says C Amusement Sales Inc., 316 Georgia Appellate at 736 says here the defendants have not even alleged and certainly have not proven that the DA received any benefit contingent upon the outcome of this case. Contingent upon the outcome of the case. Well, it was alleged that I would disagree with the state here, because it was alleged that even the way that these defendants were prosecuted, it would take a substantial amount of time, which means there's more money for the state to prosecute these defendants, which if Nathan Wade is on the case, that means there's more money for him to gain over the course of time, as they're going through these trials of the defendants, which means that, you know, if there's a continuation of trips, dinners, overseas plane tickets, whatever she's got going on with him, there's some sort of exchange of benefit, then there is an appearance that there is a benefit that is a result of the outcome of the case, in the sense that the longer this case goes, the more money he makes. And if they're together, I mean, they say they're no longer together, but if they are, then over time, and if they're doing the things that they've been doing over the past year and a half, 2 years, then she stands to benefit from it. So this is arguable to me. I mean, that might be a weak argument, but I'm just saying it's arguable. Okay. All right. So a nebulous alleged benefit that is either not personal or two, not directly tied to the outcome of the case. Traditionally, the conviction of the defendant is not enough to warrant disqualification. She was that's interesting. All right. And she says see Sutherland, and she gives the statute for Sutherland. The disqualification not appropriate where the criminal charges have no factual connection whatsoever to the alleged personal interest in the outcome, and neither proceeding would in any way have effect upon the other. All right, let's keep going. Otherwise, as this court observed at the hearing, any alleged improper personal benefit received by the district attorney under any circumstance would disqualify her from prosecuting every case in which she signed her name to the indictment. That is obviously an unworkable interpretation of the law. Okay, that's interesting. Okay, let's move on down to C, guys. So C is the remaining cases relied on by the defendants demonstrate that no disqualifying conflict of interest exists here. Okay. The fourth category of cases relied on by the defendants, a single case is what they're relying on for this. It's Davenport versus the state. And this is a case from 1981, Georgia Appellate Division. It says concerns a defendant's right to a fundamentally fair trial. So in Davenport, the court held that the defendant charged with pow-powing her estranged husband was denied a fundamentally fair trial, where the DA had previously represented the husband in the divorce proceedings that were pending at the time of the shooting. And the DA was cognizant of information and incidents that occurred between the victim and the defendant by virtue of his representation of the victim in the divorce proceedings. And 3, the DA sat at the counsel's table for the entirety of the trial. So the court held that the public policy prohibits a DA from prosecuting a case while representing the victim of the alleged criminal act in a divorce proceeding involving the accused. So that is a conflict of interest. And so both the facts and the legal principles in Davenport are far too remote from the present case for that case to be applicable here. Okay, so let's keep going. So it says the final category of cases relied on by the defendants involves cases where the disqualification was found not to be improper. A special prosecutor who accepted future employment with a law firm that previously represented a prosecution witness in a collateral matter was not grounds for disqualification because no actual conflict was shown. Okay. They cite a case, Whitworth versus the state. This was 2005. Supreme Court of Georgia has repeatedly held that an actual conflict of interest is required to warrant reversal for failure to disqualify. And she is sticking to that actual conflict of interest versus the appearance of a conflict of interest, and assuming that the state is thinking it will be much harder to prove the actual conflict of interest. Okay, so let's keep going. It says number 2 here, emphasis added on that actual conflict of interest, what I just stated, not that appearance of one, but the actual conflict of interest. So 2, a district attorney's office investigator's close personal friendship with a victim was not grounds for disqualification. And that was, okay, let's go back again. A DA's office, a district attorney's office investigators close personal friendship with the victim was not grounds for disqualification. That was in Head versus the State. That was in 2002. And 3, a prosecutor's statement to the media after a hung jury that the score is 35-1 for conviction, and that there is a substantial reason to believe the defendant is guilty did not amount to either forensic misconduct or any other grounds for disqualification. Okay, that's in Georgia as well. None of these cases suggest that a district attorney may be disqualified based on anything less than an actual conflict of interest. She is going to hang her hat on that because it's pretty clear that the appearance of a conflict of interest exists. So it's much harder. Did the defendants prove the actual conflict of interest? I'm not sure, but I'm not sure what the judge thinks, but definitely on the appearance, I think that was established. Let's move on down. Number 3, multiple Georgia Supreme Court cases clearly established that Georgia trial courts are not authorized to disqualify an elected district attorney absent an actual conflict of interest. An appearance of a conflict of interest is insufficient. And this is the basis really for her entire brief here, I think. It says there are 2 generally recognized grounds for disqualification of a prosecuting attorney. The first such ground is based on a conflict of interest, and the second ground has been described as forensic misconduct, and that is in Williams, 258, Georgia. But under the Georgia law, conflicts of interest have been found only where a prosecutor previously has represented the defendant with respect to the offense charged. Okay, read that again. Under the Georgia law, a conflict of interest have only been found where a prosecutor previously represented the defendant with respect to the same offense that is being charged and has consulted with the defendant in a professional capacity with regard thereto, or where the prosecutor has acquired a personal interest or stake in the outcome of the proceedings. No other disqualifying conflict of interest has ever been recognized under Georgia law. Moreover, as the Georgia Supreme Court again reiterated less than a month ago, an actual conflict of interest is required for disqualification of a prosecutor. And they have Lee, 2024, Georgia, and Lexus 31 at 2. So it says the trial court did not abuse its discretion by failing. Again, the trial court did not abuse its discretion by failing to disqualify the assistant district attorney, absent an actual conflict of interest. Okay, let's move on down. It says this has been the unchanged law of the state for decades in Blumenfield versus Bornstein. The Georgia Supreme Court considered whether a trial court erred in disqualifying an attorney based on an appearance of impropriety that resulted from the fact that 2 lawyers representing opposing parties in the matter were married. Okay, so that's an attorney, one representing the plaintiff, one representing the defense. Okay, that is an appearance of impropriety. Okay. It says that they erred in disqualifying the attorney based on the appearance. So they did disqualify them, but they're saying it was an error. So the court recognized that although the issue has never been squarely addressed in Georgia, courts in other jurisdictions have rarely been willing to disqualify an attorney based on the appearance of impropriety alone, where there is no danger that the actual trial of the case will be tainted. The court reversed the trial court and rejected the notion that trial courts are authorized to disqualify attorneys based on the appearance of impropriety. So the appellees have not shown us a case where a per se rule was applied to disqualify an attorney on the basis of an appearance of impropriety alone. The Georgia cases cited by the appellee do not stand for the proposition that a trial judge is authorized in Georgia to disqualify an attorney solely on the basis of an appearance of an impropriety. Okay, and they emphasize the part that they want to highlight to that judge. Again, significantly, the court did not restrict its language here to status-based conflicts, and the state of the law has not changed since Blumenfeld was decided more than 40 years ago. So based on the state's reading of the case law, no appellant case in this state, they're saying, has before or since Blumenfeld ever authorized a trial judge to disqualify a prosecutor solely based on the appearance of a conflict of interest. All right, so this is what Scott McAfee initially said in his opening statements for that hearing. He said the appearance of a conflict could potentially disqualify Fani Willis, the DA. So she's basically saying, trial judge, this has never been done before. You need to establish that an actual conflict of interest is here and not this appearance of the conflict, because that's a lower standard. Okay, let's keep going. It says the concept has been reinforced in multiple cases since Blumenfeld. In Lyons versus the state, the Georgia Supreme Court refused to accept a defendant's argument that the trial court erred in refusing to grant his motion to disqualify the DA based on an appearance of impropriety. I mean, they cite the case, but I'm not going through all of that. Okay, it says the court reiterated that a theoretical or speculative conflict will not impugn a conviction which is supported by competent evidence. Okay. And they're quoting Lamb. Okay, so it says, while Lamb did not involve disqualification of a DA, in that case, the court reiterated that an alleged conflict must be palatable and have a substantial basis in fact. Okay, so I don't know why they added this, because this is not an alleged conflict. They actually stated that it was true, so it's not alleged anymore. Okay, so it says decisions of the Georgia Court of Appeals are in accord. In Whitworth versus the state, the court affirmed a trial court's denial of a motion to disqualify the prosecutor where no actual conflict of interest was shown. The Supreme Court of Georgia has repeatedly held that an actual conflict of interest is required to warrant reversal of a conviction for failure to disqualify. A theoretical or speculative conflict is simply not sufficient. And that is based on 1999 case law. Okay, so let's keep going. It says every Georgia case that has addressed the issue has reached the same conclusion. In order to authorize a trial court to disqualify an elected DA, an actual conflict of interest must be proven. No prosecutor in the state has ever been disqualified on the appearance of a conflict. Okay, let's move on down to number 4. And this is OCGA, section 1518.5, confirms multiple Georgia cases holding that an actual conflict of interest must be shown to disqualify an elected DA. I don't know why the state thinks that an actual conflict has been proven. I think it can be argued that an actual conflict does exist here. It's interesting that they're hanging their hat on this when even this is shaky ground. So to me, this is my opinion. Obviously, I'm not the judge. I mean, this is just my opinion. Okay, let's move on. It says the cases set forth above that hold that proof of an actual conflict of interest is required to disqualify an elected district attorney are confirmed by the language of OCGA section 1518.5. The statute explains the procedure for the appointment of a point of substitute. When a district attorney's office is disqualified from interest or relationship to engage in prosecution. So the statute makes no mention of disqualification due to an appearance of a conflict of interest based on personal interest or relationship. This court must construe the statute according to its terms and give words their plain and ordinary meaning. Sounds like stuff we learned a Plain and ordinary meaning, guys. Plain and ordinary meaning. Okay, that was LaFontaine versus Signature Research. Anyway, moreover, this statutory language has remained unchanged since the state's first codification of the common law, which took effect on January 1st, 1862. When a solicitor is absent or indisposed or disqualified from interest or relationship to engage in a prosecution, the presiding judge must appoint a competent attorney of the circuit to act in his place. Okay, let me go over that part again. So they're saying that the statutory language has remained unchanged since the state's first codification of the common law, which was back in 1862. When a solicitor is absent or indisposed or disqualified from interest or relationship to engage in a prosecution, the presiding judge must appoint a competent attorney of the circuit to act in his place. Okay, that's fine. That's basically saying that if they're disqualified, judge has to appoint someone. All right, so emphasis added on the disqualified from interest or relationship. Okay, the language is old as Georgia's statutory law itself and should guide the courts. All right, references to Caesar's wife in certain cases do not lessen the requirement that an actual conflict of interest must be shown to disqualify an elected district attorney. All right, let's keep going. Okay, number 5. So it says at the hearing, let's start back the title of number 5. It says references to Caesar's wife in certain cases do not lessen the requirement that an actual conflict of interest must be shown to disqualify an elected district attorney. Okay. References to Caesar's wife in certain cases do not lessen the requirement that an actual conflict of interest must be shown to disqualify the DA. Okay, so at the hearing on this matter, the court also referred to the occasionally invoked example of Caesar's wife. The language to which the court referred was first used in Nichols versus the state. And the administration of the law, and especially that of the criminal law, should, like Caesar's wife, be above suspicion and should be free from all temptation, bias, or prejudice, so far as it is possible for our courts to accomplish it. This was 17 Georgia Appellate, 606. Okay, it's cleaned up. It says the court noted this language and questioned whether it suggests that something less than an actual conflict of interest could suffice to disqualify a prosecutor. The state has not found any case that has ever made such a holding. And in State versus Sutherland, the Georgia Court of Appeals went out of its way to reinforce the differing standards between prosecutors and fact finders, such as the judges or the juries. So they've made some sort of distinction there. Shortly after quoting the Caesar's wife language found in Nichols and other cases, the court explained, Mr. Wilson's civil action is entirely separate from the appellee's criminal prosecution. And assuming that Mr. Thacker is a partisan, he has not been shown to be such a partisan as would disqualify him from proceeding with the prosecution of the appellee. While the prosecuting officer should see that no unfair advantage is taken of the accused, yet he is not a judicial officer. Those who are required to exercise judicial functions in the case are the judge and the jury. The public prosecutor is necessarily a partisan in the case if he were compelled to proceed with the same circumspection as the judge and the jury, there would be an end to the conviction of criminals. That was the State versus whole case law, Scott versus the state back in 1935. Because the record shows nothing to suggest that in his handling of the prosecution of the appellee that Mr. Thacker was acting in his personal or individual character or for his personal or individual interest, but in his character as an officer of the law, specially charged by the statute to perform this particular duty. He was not employed by any private person to prosecute, and his acts in connection with the instant case were not with a view to the interests of any client, but alone to subserve public justice. And then we go on to say Pinky versus State, the 22 Georgia Appellate. This was 1918, again, very old case law. The trial court erred in granting the appellee's motion to quash the indictments on the ground of Mr. Thacker's disqualification. Okay, let's keep on going. Sutherland, 190 Georgia Appellate, in this section 607, 608. Sutherland thus acknowledges the example of Caesar's wife noted in Nichols and other cases, but emphasizes that prosecutors are not held to the same standard as judges. Instead, prosecutors can only be disqualified in cases where they are acting in their own personal or individual interests rather than in their character as an officer of the law, specially charged by the statute to perform this particular duty. Let me go back and read this again. Instead, prosecutors can only be disqualified in cases where they are acting in their own personal or individual interests rather than in their character as an officer of the law, specially charged by the statute to perform this particular duty. Oh, wow. She's saying, so, okay, my character as the DA doesn't bar me from, according to this case law, doesn't bar me from my duty. Now, if I'm acting on my personal or individual interest, then yeah, I can be barred from and disqualified from this case if there's an actual conflict of interest. But based on my character as an officer, no, I'm not. That's an interesting argument. Sutherland also invokes, yet again, the example of private prosecution. For example, contingency fee-based prosecution as an example of the sort of actual conflict of interest required for disqualification. Indeed, in every case the state has found involving disqualification of a prosecutor based on personal stake of interest, that personal interest has consisted of the prosecutor enjoying some sort of direct gain contingent upon the outcome of the criminal case. Without such a personal interest sufficient to wholly displace the prosecutor's role as an officer of the law, disqualification is not authorized. Do you guys think that the defense proved like a substantial ground or an actual conflict versus just the appearance of the conflict? And do you think that they sort of proved that Fani has a personal interest that that she would benefit from based on the relationship with Nathan? Or do you think any of this even applies to, this was interesting. Let's move on down to number 6. Because the defendants have not met their burden of proof, either an actual conflict of interest or forensic misconduct on the part of the DA. For the reasons set forth above, the court should not disqualify the Fulton County DA's office from prosecution of this matter where the evidence before the court fails to demonstrate an actual conflict of interest or forensic misconduct on the part of the DA by a high standard of proof. This was in McGlynn. To whatever extent the defendants allege the DA received a benefit arising out of this prosecution, they have made no allegation and have offered no evidence that the district attorney has any improper, direct, or material personal stake or interest in the outcome of these proceedings sufficient to authorize disqualification. I disagree with that, but let's keep going. The defendant's suggestions concerning what constitutes an improper personal stake or interest are both unsupported by law. This is where it gets interesting. The defendant's suggestions concerning what constitutes an improper personal stake or personal interest, they're saying that it's both are unsupported by law and, as the court rightly pointed out at hearing in this matter, entirely unworkable. An application of the actual legal standards reiterated by Georgia courts and by statute as set forth above leads to only one authorized outcome. The indictment should not be dismissed and the Fulton County DA's office should not be disqualified. And this was respectfully submitted on the 5th, so 3 days ago, as of March 2024, by Fani Willis. I need some tea here. All right, guys. So that is it for tonight in regards to the Fani Willis supplemental brief that she presented to the judge in regards to the standard that should be held for disqualification of an elected district attorney, not just any prosecutor, an elected DA. She makes some valid points there. We'll see how the judge, he decides in this case. Again, there is not much case law regarding a case similar to hers. So I think that's it, guys. For me, sure, if you like this content, be sure to like and subscribe. Hit that subscribe button, guys. Hit that notification bell so that you're notified as I post videos and you get the latest on the scoop on what's going on. All right, so I will talk to you next time. You guys have a good evening, and thanks for joining this evening.